We can't allow the court system to have a chilling effect.
Senator Kennedy.
Thank you, Mr. Chairman. Thank you for being here. Professor Mascott, this case that we're talking about, Trump v. United States, it was before the United States Supreme Court because the Biden administration decided to criminally prosecute former President Trump. Is that correct?
Yes, Senator.
And in fact, President Biden's lawyer actually asked for expedited review and an expedited decision by the Supreme Court. Is that correct?
Yes, the prosecution would have found expedited review helpful.
When the court handed down its opinion, well, strike that. The title of our hearing is, quote, "When the president does it, that means it's not illegal." And Chairman Durbin explained what he meant by that, but I just want the record to be clear. Did the Supreme Court, in its opinion, ever say, quote, "When the president does it, that means it's not illegal"?
No, that doesn't appear in the opinion.
All right. At the oral argument of this case, President Biden's lawyer actually conceded, did he not, that core functions of a president should have absolute immunity?
Yeah, I do think there's agreement that core functions should have immunity.
In fact, President Biden's lawyer said, quote, "Core functions can't be regulated at all."
That's correct.
Close quote.
Yes.
Okay. What is forum shopping?
Forum shopping is the act of trying to find a court that you think is going to rule favorably to you.
Does it go on in the United States?
Many folks think that it does.
Yeah, it does. It's hard to stop. Let's just stipulate for a moment that America's withdrawal from Afghanistan was not a model of efficiency. People died, including Americans. Can you imagine a scenario with respect to President Biden, now former President Biden? Can you imagine a scenario in which a district attorney in a jurisdiction that repeatedly voted overwhelmingly against President Biden and whose voters did not like President Biden? Can you imagine a scenario in which an ambitious district attorney, after President Biden is out of office, could bring a charge against former President Biden for criminal negligence in the death of Americans? Can you imagine that?
Well, Senator, that would be very troubling, and so that's one of the things.
But can you imagine it happening?
I could imagine district or attorneys wanting to bring such an action. Sure.
I mean, now that we've decided that former presidents can be prosecuted, this current case before us is the first instance, but I fear it's not going to be the last. Now, let's suppose this ambitious district attorney in an anti-Biden jurisdiction or venue decided to prosecute former President Biden, which I think would be a mistake. But he meaning former President Biden, would have to defend himself, wouldn't he?
Yes.
And suppose he won, he'd still have to pay his lawyer, wouldn't he?
That's true.
Are lawyers cheap?
Only those of us who teach
No,
law.
strike that. I know they're cheap. Are they inexpensive?
No, they're not.
So President Biden could spend millions of dollars.
That's true.
Even if he won.
Yes, sir.
Now, let's suppose after that trial was finished, another ambitious district attorney in another venue or another jurisdiction decided to do the same thing. And then another. And then another. Can you understand what the court was talking about when it said we can't allow the court system to have a chilling effect on a president, any president, in making these decisions? Can you understand that?
Absolutely. The risk of facing that would certainly significantly impact how a president would make decisions in office, and that's the last thing we want.
Can I have 30 more seconds, Mr. Chairman? I don't want to mispronounce your name, sir. Don't count my fumbling around against me. Mr. Lacavara?
Never have.
You were vociferous in your criticism of this opinion that the words presidential immunity don't appear in the Constitution. Is that right?
That's part of it, yes, sir.
Do the words separation of powers appear in the Constitution?
No, I acknowledge that there is a structure called the separation of powers.
Is there any doubt in your mind that we have separation of powers in the United States Constitution?
No, and I think it's important to understand what the separation of powers does and does not imply. And
Right.
what it does not imply, in my judgment, is the kind of immunity that the Supreme Court established here.
Okay. Thank you, Mr. Chairman.
Senator Cruz?
Thank you, Mr. Chairman. The nub of the Democrats' argument today is that the concept of presidential immunity is somehow unprecedented, is somehow remarkable. That claim is utterly ahistorical and disconnected from the entire constitutional history of the Republic. General Mukasey, before 2023, how many times has a president of the United States been indicted?
None.
Before 2023, how many times has a former president of the United States been indicted?
None.
In the last 2 years, how many times has President Donald J. Trump been indicted?
4 times, I believe.
Now, many presidents of both parties have engaged in controversial actions, and yet none of them have been indicted. Let me ask you, General Mukasey, if a private citizen were to erect an internment camp and to forcibly kidnap American citizens, to single them out because of race, and to imprison them based on their race, would that private citizen be subject to criminal prosecution?
Would.
When President Franklin Delano Roosevelt did the exact same thing and erected Japanese internment camps, was FDR prosecuted?
He was not.
Let me ask you, similarly, if a private citizen were, say, to detonate a nuclear weapon over a city and kill over 140,000 people, and then if that private citizen a few days later detonated another nuclear bomb over another city and killed 75,000 people, could that private citizen be criminally prosecuted?
He would.
Was President Harry Truman prosecuted for detonating nuclear weapons over Hiroshima and Nagasaki?
He was not.
All right, how about this? If a private citizen launched a weaponized drone and killed a United States citizen, could that private citizen be criminally prosecuted?
He would.
Was President Barack Obama criminally prosecuted when he killed United States citizens using drones without notice and without due process?
He was not. Although, as far as due process is concerned, I believe the comment of my successor to that question was that Anwar al-Awlaki got, quote, all the process that was necessary.
Well, although I suspect he might disagree with that assessment were he able to present his case.
Right.
All right. Let's contrast that with the rules that govern other federal officials. You were a judge for 19 years. As a federal judge, did you have immunity from your official acts?
For my official act, yes.
Do federal prosecutors have immunity from their official acts?
They do.
Now, the distinction between official acts and personal acts is not a terribly shocking distinction. Under the decision of Trump versus United States, if any president walks onto the sidewalk and just shoots a citizen, is that president liable to be prosecuted?
He is.
How about this? If a president steals funds from his campaign, does that president face criminal liability?
He does.
How about this? If a president sexually assaults, let's say, an intern in the Oval Office, is the president subject to criminal prosecution for that?
He could be.
So that distinction, again, is not a shocking distinction. The Founding Fathers vested the executive power in a single president of the United States. What we have seen in the last 2 years is we have seen Democrats deliberately weaponizing the Department of Justice and our legal system to target their political opposition. It is not an accident that every indictment against President Trump was brought by a Democrat and was brought after he announced his campaign for President of the United States. Understand, the target of those indictments was not ultimately President Trump, it was the voters. It was prosecutors who were terrified that the voters would choose to re-elect President Trump. One of the great things about the United States is we're not a banana republic. Since 2000, the nation of Pakistan has had 6 former prime ministers prosecuted and convicted. Brazil has had 3 former presidents arrested and imprisoned. Last year, Nicaraguan President Daniel Ortega arrested, charged, and imprisoned 40 political opponents. General Mukasey, you are Attorney General of the United States. Is it the proper role of the Department of Justice to prosecute and target the political opponents of whoever happens to be President of the United States?
It is most assuredly not.
Thank you.
Senator Lee.
Thank you, Mr. Chairman. Thanks to each of you for being here. Chief Justice John Roberts, in his majority opinion in the case that we're discussing today, noted that, quote, "This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency." Look, we wouldn't be here today if the progressive left, after trying not once but twice to impeach President Trump, brought the first criminal prosecution of a former president in our nation's history based on acts undertaken during his presidency. And they all celebrated the politicization of federal and, in many cases, state prosecutors when all this happened. Now, look, my colleagues on the other side of the aisle, some of them at least who we've heard from, one could argue that they made up their mind about this case long before reading the briefs, much less the opinion or even the cert petition, just based on one name, on the name Donald Trump. The fact that the petitioner in that case was named Donald J. Trump meant that they were going to be against whatever it is that he argued and any court ruling that maybe came down on his side. But look, all of this is part of a pattern and practice of lawfare, a mechanism by which a number of prosecutors, including many elected prosecutors who ran specifically on the platform of criminally prosecuting Donald J. Trump and have prosecuted on going after other people whose political views that they don't like. And so in this respect, it reminds me a little bit of what our colleague, Senator Chuck Schumer, did to threaten 2 members of the Supreme Court, Justices Kavanaugh and Gorsuch, when he went to the steps of the Supreme Court back in 2020, and he delivered this choice soundbite. Quote, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions." So look, the left knew their preferred outcome, in this case, based on the criminal defendant, on the petitioner before the Supreme Court, before the first arguments were made at the earliest stages. This is something that we need to look to. Now, some of my colleagues have commented today about the legitimacy of the opinion, including suggesting that it was borne out neither by a textualist nor an originalist analysis of the constitutional text in question. Professor Mascott, I'd like to start with you. Tell me what you think of that assessment, that this is somehow counter-textualist or counter-originalist for the court to have reached this conclusion regarding presidential immunity?
Thanks, Senator Lee. Well, as the opinion notes, it's based on longstanding structural understandings of the constitutional system. For example, we have a concept of sovereign immunity. The government itself has a little bit has a well of immunity, and the president and the vesting of the executive power in the vesting clause has inherent immunity. And this is the doctrine that was recognized decades and decades ago, repeatedly by the Supreme Court, albeit in the civil context, and even during the Clinton administration and before. And it's essential to the president to be able to do his job. Not that every action he's going to take is always going to be deemed legal. There are plenty of ways to challenge actions in court, to enjoin actions, to go against the action itself, to defund actions, to impeach and convict a president, but not to subject him to criminal prosecution for doing his job.
So in other words, they're not making this up. It is rooted in text. It is rooted in the structure. But there are centuries-old precedents that we rely on, some of which predate the founding of our republic. Is that right?
That's correct, and in the concept of executive power itself, properly historically understood.
And the President of the United States is himself the living embodiment of the executive branch.
That's correct.
the
He's the only individual who sits at the top alone of a branch of government.
Right. And so these things were born of necessity many centuries ago, in many cases before the founding of our republic, but were understood at the time the Constitution was written. General Mukasey, when you look at what would happen if we didn't have this doctrine, even if we just didn't have this ruling, let's say if the outer perimeter category identified by the Supreme Court, that seems to be attracting a lot of the scrutiny today, if that did not exist, how would that impact the American people through the route of presidential actions? In other words, if a president, let's say, for example, President Clinton, when deciding to order a military strike that happened to arise at the same time certain scandals were erupting surrounding Monica Lewinsky, if that could subject him to some type of criminal prosecution, or a grant of a pardon at the same time somebody else had an interest, as you mentioned in the case of Mark Rich. What kind of impact would that have on the American people through their president if presidents had to look over their shoulder constantly in evaluating their own personal future stake in this and what could subject them to criminal prosecution?
Well, in the case of the attack that President Clinton authorized, which was decried by some people as a diversion, obviously the security of the people would be compromised because there would be hesitation over the order to direct that attack, notwithstanding that it was designed to protect the people of the United States from foreign hostile actors. As far as the pardon, that if that was a legitimate exercise of presidential authority, the ability to grant pardons and would itself be compromised.
In other words, we would be opening up a hornet's nest. This would be a Pandora's box, to put it mildly, that we would be opening if we didn't have this.
Presidency would be whittled away by repeated considerations of possible future consequences.
Thank you.
Senator Rono.
Thank you, Mr. Chairman. I thank all of the witnesses. We have a Supreme Court majority busy overturning decades-long precedent, and so let me cite some of the better-known decisions. And I do this as illustrative of the Supreme Court's willingness to overturn precedent as well as create new precedents. For example, in Citizens United, we learn that corporations are people and opening the floodgates, basically, to the dark money that is flooding our elections. In Shelby County, we see the Supreme Court eviscerating a major part of the Voting Rights Act. And in Janus, the Supreme Court overturns decades-long precedent that enabled public sector unions to collect fees even from non-members who they had to represent. Excuse me. I heard mentioning of Korematsu. The thing is that when the Supreme Court makes a decision, even if it's wrong, it can stand, and the Korematsu decision stood until 2018. So when the Supreme Court makes a decision, it has ramifications of longstanding. Then we have Brnovich, which, again, it further limited the protections of the Voting Rights Act. And by the way, did I mention Shelby County, where suddenly the majority decided that to eviscerate, as I said, the Voting Rights Act, and soon thereafter, 13 states passed all kinds of voter suppression laws, and then under Brnovich, they went even further. In a more recent case, Bruin, the Supreme Court, again, decided that to sustain gun safety laws, they should look to precedents going back to 1791. And of course, we have the Dobbs decision, which overturned almost a 50-year, what women in this country thought was a constitutional right that the Supreme Court should be protecting. More recently, in 2023, we have the Harvard affirmative action case, which the Supreme Court tossed out, meaning that Harvard's ability to refer to race as a way to have a more diverse student body, that was tossed out. And then, because of the outcome of the Bruin decision and all of the aftermath of that, there was another case where they had to kind of walk back their Bruin decision. And then we have the more recent 2024 decision where the Supreme Court overturns a Chevron decision, and that's going to create all kinds of problems. And now we have the Supreme Court creating new precedent in terms of presidential immunity, and this is going to have far-reaching consequences. And of course, you know, it's already having impact, totally foreseeable impact on the Trump cases. In the DC case, the parties are briefing issues raised by the Trump decision, and Judge Chutkan is going to have to make certain fundamental decisions on that. There's no question that this immunity decision helps Trump. In the Florida case, it was totally dismissed by Judge Cannon based on, of all things, Justice Thomas's, it wasn't even part of the majority decision. So it's like, wow, that just raises so many questions that she would toss out the case based on Justice Thomas's concurrence. And then we have the New York case where Trump is wanting to set aside all 34 convictions. So we have a Supreme Court that is making these kinds of far-reaching decisions, and in this case, I don't see how anybody can say that it doesn't help Trump. So I have a question for Ms. McCord. You know, I think you went into this a little bit with the questioning from our chair, but if you can't bring in the motivations, regardless of whether the motives may have been based on his responsibilities as the president, how can you prove that the president was doing things that should hold him criminally liable?
Well, certainly mens rea that includes specific intent to commit a crime, and that is an element of every one of the crimes that's charged against Mr. Trump in the January 6th prosecution. That's required at trial. The Supreme Court has actually said, though, that you can't even look to motive when determining whether the allegations involve official acts or purely private acts. And again, I think that hamstrings the judge in even making those determinations, because if you can't look at the intent, it makes it very difficult to determine in some cases what might be on which side of the line.
So if we look at the pragmatic and practical impact of this immunity decision, I don't see how a prosecutor can overcome the immunity of the president if you can't bring in motives. So as far as I'm concerned, this is a decision that should not be allowed to stand. What do you think about a constitutional amendment that would make it very clear that no one is above the law, including the President of the United States? I ask that of Ms. McCord.
Yes, I'm familiar with your and your colleagues' proposed constitutional amendment, and I think that that is something, you know, that legal scholars can study, but it seems like it is a response that to this opinion. I would note potentially the need to carve out actual core constitutional powers, but I don't think the amendment was necessarily intended to override those.
Thank you, Mr. Chairman.